Welcome to Fairly Competing, the show providing in-depth analysis of trade secret law and the law of non-competes and other restrictive covenants. Whether you're a business owner, CEO, in-house counsel, HR executive, or other employee, or a new lawyer or advanced practitioner, join us for a discussion on the latest trends and hot topics, evolving federal and state laws, key developments, and other emerging issues in trade secrets, non-competes, and employee mobility in today's knowledge economy. And now, here are your co-hosts, John Marsh, Ben Fink, and Russell Beck.
Thank you, Erica. Here in Boston, Russell Beck.
Here in Atlanta, Ben Fink.
And here in Columbus, John Marsh.
Well, fellas, it's been a monumental week. Russell, congratulations. I know that you in particular have spent a lot of time and energy thinking about and writing about and talking about the FTC's non-compete ban. And of course,
I've been an active bystander, I think is maybe the way to describe
it. But, you know, it was a monumental week in the sense that the judge, who I'll throw in a plug as the former president of the Emory Law Alumni Board, she's an Emory Law alumnus, reached what we all, I think, agree is the right result and set aside the FTC's non-compete rule. I think the pleasant surprise, and I know you'll talk a little bit more about this, was that her ruling, even though her preliminary ruling on the preliminary injunction was limited to the parties in the case, her ruling set aside the rule for all purposes, for all parties, for all companies, and that was a welcome result, if for no other reason, regardless of whether you're in favor or against the rule or believe she got it legally correct or incorrect. At least we don't have the chaos of having a ruling or some ambiguity about what companies need to do beginning on September 4th. So with that introduction, Russell, I'll let you talk about, you know, what happened, what did she say, what was the ruling, and what does that mean for the rule going forward?
Terrific. Thank you. And so, yeah, I mean, you've highlighted what the kind of the key takeaway here is, that the rule has been vacated. So let me walk us through the process. This was the first case filed, people may remember, it was Ryan versus the FTC. It was filed literally within hours, if not hour, of when the FTC issued its rule back in April. And so the initial ruling out of the court on the preliminary injunction was just as you said. The court had basically said, look, you know, as for the parties, the FTC can't enforce the rule, but I'm not going to expand that beyond just the parties. So that gave people a little bit of worry about what a final rule would look like. The final rule was originally scheduled for the end of the month, for August 30th. If it went the same way as the preliminary injunction, people, all three of us included, and our clients, I'm sure, were very concerned about what would happen in those few days over Labor Day weekend when people needed to comply with the rule or sue the FTC or just ignore the rule, whatever it was going to be. And so the nice thing was the court ruled early, and the court cleared up all the confusion for everybody at this point. And what the court did was it looked at the challenges. It was ruling on summary judgment, and it looked at the challenges that were brought by the plaintiffs. They were primarily under the Administrative Procedures Act. The court explained that the Administrative Procedures Act requires courts to hold, and I'll quote the language, courts must hold unlawful and set aside agency action, findings, and conclusions found to be arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with law, contrary to constitutional right, power, privilege, or immunity, or in excess of statutory jurisdiction, authority, or limitations, or short of statutory right. And all of those standards were at issue in the case, but the court focused on two. And the court was actually very clear. Like once the judge got through the particular issues that she was focused on, she didn't need to address the others, and so she didn't. The two that she focused on were, number one, statutory authority, and number two, the arbitrary and capricious standard. On the statutory authority, she specifically said that the FTC lacks substantive rulemaking authority with respect to unfair methods of competition. That's it. this was an unfair method of competition, according to the FTC, that is the use of non-competes. She said the FTC did not have the authority to issue that rule. So that should be the end of it from that standpoint. But she continued on. And I do want to note, I had commented on this in my blog, that I was particularly pleased that whether she intended to or not, she brushed off Matt Gaetz's attempted power grab in his amicus brief, where he said, Your Honor, the FTC has to come to us and we evaluate whether their conduct was appropriate or not. And it's like, no, that Congress doesn't do that. It's the courts that do that. And she specifically said the judiciary remains the final authority with respect to questions of statutory construction and must reject administrative agency actions which exceed the agency's statutory mandate or frustrate congressional intent. And so what's great is it's kind of like, thank you, Matt. You're not going to expand the powers of Congress. We're keeping this all within the courts. And then she found that the FTC did exceed its authority. She then turned to the arbitrary and capricious standard and looked specifically at the rule as it had been passed by the FTC. And her conclusion was one size fits all is unreasonably overbroad. And because the FTC rejected different options, more narrow options, without a legitimate analysis of those other options, it was overly broad. It was arbitrary and capricious. I will note that binding in particular was something that those of us who signed on to the letter that we sent to the FTC last year after they issued their proposed rule, we had specifically made that point to the FTC to try to get them to think about maybe you shouldn't be doing such a broad one-size-fits-all approach. Instead, you should be doing a more tailored rule that really focuses in on the abuses rather than the use of non-competes generally. And so the court echoed all of that. It may as well have been taken right out of our letter, which I was very pleased with. Once the court got through that, the next question was, well, what's the remedy? And this is where everybody was worried. This is where the rest of us were for the past month or so wondering, okay, will the FTC, will the court do the same thing at a final decision that it did at the preliminary injunction and limit its relief to just the parties? And the good news is, no, the court did not do that. The court actually said that the APA directs the reviewing court to hold unlawful and set aside any agency action that, is ultra vires or arbitrary capricious. And so that's exactly what it did. And the ruling from the court, I will read because it can't be more clear than this. The court said the APA does not contemplate party-specific relief. Quoting the Fifth Circuit, the court said, setting aside agency action under Section 706, which is under the APA, has nationwide effect, is not party restricted, and affects all persons in all judicial districts equally. And then the court said that the rule is unlawful and it is hereby set aside and shall not be enforced or otherwise take effect on September 4, 2024, or thereafter, just lest there be any doubt about this. So that's the rule.
Hey, Russell, let me ask a quick question. And I'm not sure how much this matters as a practical matter to just about anybody, but there was a lot of discussion before she ruled about whether she was going to vacate the rule. And I'm not an APA expert by any means. And is there a distinction between what she did in setting it aside and vacating it, or is that essentially the same thing?
So I am also not an APA. My education in the APA has come through this this case and the other two. But no, I don't think it's any different. I think this is vacating the rule. But if somebody is listening to this and wants to correct us, please do. But I'm pretty sure that the setting aside is the vacating. So at this point, the rule is gone, and we'll talk about what that means. But in terms of kind of what we can expect for next steps, so the FTC can make a decision about whether it's going to appeal this or not. If it appeals it, it's going to appeal it to the Fifth Circuit. I think we all can predict the outcome of an appeal to the Fifth Circuit, and we can also predict the outcome of an appeal, cert to the Supreme Court. So I think we are where we are. And I saw an interesting comment from a lawyer in the press yesterday that I thought was exactly right on point. And he said the FTC really has a tough choice here because either they live with what they have or they try to reverse it by appealing it. But if they appeal it and lose, as they likely will in the Fifth Circuit, then now they've got a circuit court saying that this is outside of their authority. Right now, it's just a district court. So I think we'll see what winds up happening if the FTC does appeal it or not. In the meantime, there are 2 other cases that are still pending. It seems to me that this should be res judicata, given that it is a final decision out of the district court, that the FTC should not be able to collaterally attack it in those other cases. But I already emailed the Pacific Coast Legal Foundation this morning and said, please drop your case. So we'll see.
Yeah. So Russell, I was going to ask you about that. So, we've got these other cases, right? There's the ATS case in Pennsylvania. We've all been scratching our heads since that was filed, why they filed, in particular in that jurisdiction.
Yeah.
Where predictably, they got a less conservative judge who reached a different result, at least at the preliminary injunction stage. And so where does that leave us? And you're right. I mean, it seems to me that they need to immediately dismiss that case, and they're sort of doubling down on what could be considered at least a very poor judgment, if not something worse, in having filed it initially if they continue on with it. But what happens if they don't? What is the potential practical effect of having a final ruling from a Pennsylvania court that maybe is different from what the judge in Texas found?
It's a great question. I actually don't know the answer to this, because this is, now we're looking at constitutional law. We're looking at federal procedural law. My understanding is that the federal district court in Texas's ruling, now that it's a final decision, does have preclusive effect on the FTC anywhere else. And so that should be what used to be called res judicata, now, claim preclusion. And when I say now, I mean, when I was in law school, so over 30 years ago, right? I think they made that switch. But
my son, having just gone through law school, I struggled with that. I was like, what are you talking about? It's res judicata, collateral estoppel. He's dead. Like, that's like,
ancient.
Russell, do you know if there are pending motions for summary judgment in that case? Because that could complicate.
There's not. I don't believe there's anything.
So there was simply the motion for preliminary injunction that was denied. You have the equivalent of an interlocutory ruling.
That's right. And they did file the scheduling order yesterday or the day before, within the past few days anyway. And the FTC has not yet answered. So
right, that's key.
That's why it can be. Right, exactly. That's why it can be.
They file a counterclaim for declaratory relief. That'll keep it going.
Yep. And same thing for Florida, although I haven't written to those guys yet. I'm not as concerned about the 11th.
I'm surprised they haven't.
Yeah, well, they might.
Not to give them any ideas. I'm sure they're not listening to this podcast. But
why are you so sure? I assume everybody listens.
I understand Lena Khan is a regular listener of our podcast.
Joe's gives it bad reviews too.
So does Jill, apparently.
All right. So I think that's it on the cases and where we're headed with those.
So let's talk about what the other risks are, right? The FTC, as we know, on the same day they announced the rule in January of last year, they announced these enforcement actions, and they've mentioned them multiple times. There have been other enforcement actions. And then, of course, in response to this ruling, their press release about the ruling by the Texas judge said, we're going to continue our enforcement actions. But those enforcement actions, at least so far, appear to have been limited to and focused on the use or abuse of non-competes with lower wage workers, right? So, what is the risk there? And then what are the potential risks going forward in terms of Congress getting involved? We know that there have been various bills that have been introduced over the years that really haven't gone anywhere, but there does seem to be some interest in Congress in legislating in this area. So that is another risk that does exist, although it's probably longer term. And then we were talking about, and I can talk more when we get to it, about the potential risk associated with the various state mini FTC acts and what potential enforcement actions could arise out of those. And that varies significantly from state to state.
So why don't we take them one at a time? And John, any part of this you want to cover?
Yeah, happy to. I'm happy to chime in, but again, I'm going to be somewhat more deferential to you. I mean, again, drawing you into the discussion on this point, it's my understanding, largely based on what you've reported, that the
Probably wrong. Go ahead.
but the activity, those initial flurries of activity of administrative action that was being taken against individual companies, which they sort of announced in a flourish as to that they've traditionally and historically been governing and regulating in this area to justify that.
Right.
That those have been, at least as far as we're aware, in abeyance. I guess there was similarly a flurry of subpoenas directed at some employers, but in terms of any formal administrative action, that's been dormant while the FTC's focused its actions on the rule that's been set aside. That's at least my working understanding, but I'd be interested in hearing what you have to say, Russell.
Certainly, the only thing that really was public were those cases that they brought, and
Right.
they announced on January 4th, I think it was, of 2023, the day before they announced the proposed rule. But those, what's interesting about those, I just want to make sure that everybody has the context of those. There were 3 different cases, but multiple different parties in them. And one of them was the security guards case, right? And that one, it had there were non-competes that were being used for security guards. It was a 100-mile radius that where they couldn't compete, and if they violated it, it was $100,000 penalty, which was probably multiple years of compensation for these people. It was completely outrageous, and the FTC found that and used that as the poster child for the abuse of non-competes, which of course there are those kinds of abuses out there. And of course they should be dealt with in a way that stops them. I get that. But the other thing that the FTC did was they brought a lawsuit against, or 2 different, they're not lawsuits, 2 different enforcement actions against different glass companies. And that felt to me much more within their jurisdiction, arguably, because for those, they were focused on the market and that there was really a very small market for the movement of people. And so it did feel like at least you're paying lip service to some amount of competition between companies. And that's what the real focus was. So, there was a highly concentrated industry. And so I think for that reason, that didn't strike me as anything particularly concerning. But to your point, John, that's it. And then after that, it really, they dealt with those cases, but I don't think they filed.
I think there were a couple more. There was at least one more after that initial flurry, if not 2 or 3.
There may have been one more, but I thought there was just the ruling on one of those.
Yeah, I could be wrong.
No.
But while you're looking at that, Russell, I think it's worth talking about. So there's that risk. And then, like we were talking about, we had looked into the issue of some of the mini FTC statutes in various states. And ours happened to be based on, the client that asked for it, focused on Indiana and Illinois and Georgia and some other states. But what we found was that, in some states, the mini FTC statutes basically provide that anything that the FTC considers an unfair method of competition is arguably a violation of that state's consumer protection or mini FTC statute. And some of the state statutes have some fairly draconian penalties that the Attorney General can impose or seek to impose. And then they all or most of them have private right of action. And so I do think that, companies still need to be thinking about and looking at that. And a great example of that is this Valvoline case. And I'll give credit to my partner, Neil Weinrich, who I always, tell clients is the brains of the operation around here. But Neil uncovered this enforcement action by attorneys general in Minnesota, Colorado, Illinois, Maryland, Massachusetts, and New York against Valvoline. And, somewhat like the security guard company that the FTC went after, Valvoline is having people who are changing the oil in cars sign non-competes saying that they can't work for any oil change business with a 100-mile radius of the Valvoline location they worked at. And the attorneys general went after them and got them to agree that it would stop requiring the employees to sign those agreements and to notify current and former employees that their non-competes were no longer in effect. So very similar sort of relief from as to what the FTC obtained in the security guard and the glass company cases we were just talking about. So I do think that just because we've gotten this ruling on the FTC rule doesn't mean that the risk has completely gone away, and companies need to be aware of the continuing risks of these enforcement actions and even private causes of action against the abuse of non-competes if they violate particular state statutes.
I could not agree more. And actually, your memory was better than mine, Ben. The FTC did bring another enforcement action. They brought it back in 2023 as well. It was in May of 2023, but it was also against another company in the glass container business. So again, that same concentrated industry and the same one that they had already gone after. So I don't think there have been any since then, although again, maybe my memory is wrong here. But I think you're right. We're looking at the FTC potential enforcement actions as well as AGs. And remember, the AGs, there were a handful of them that sent 2 letters, although the particular AGs varied on the 2 letters. But there were a handful of AGs that had sent letters to the FTC in support of the FTC issuing a rule banning non-competes. And what I thought was particularly interesting about that is I don't understand how these attorneys general could send a letter to the FTC asking the FTC to essentially undo the law of the state that they are charged with enforcing. But there you have it. So in any event, the FTC and the AGs are definitely concerns at this point under the mini FTC acts.
Hey, fellas, I just got an email from a client that I'm going to throw a curveball into our discussion. Russell,
don't breach privilege. Don't breach privilege.
No, it's I'll keep it, obviously vague, but I think I'm guessing this is not the only client that had this happen. So when we first got on, I was telling Russell, as you probably had been over the last, several weeks, months, we had been sending emails to clients for whom we had written non-compete agreements, just alerting them to the rule, alerting them to the notice that was required and saying, hey, if you have questions, let us know. We just want to make sure you're aware of this. And, obviously there were various options we had all talked about what companies could do. So then, the last couple of days, I've been sending follow-up emails saying, disregard my last email. Don't worry about it in light of the ruling. Well, I just got an email from a client that said, well, SHRM, the Society for Human Resource Management, sent us a form and we went ahead and sent it out based on them sending it to us. And Russell, I can see, this is a podcast, so people can't see him. He's got his head in his hands, shaking his head like, why in the hell would you do that? So now, if companies did send out the notice, now what? I think you're kind of screwed, right? That the argument's going to be, you told me my non-compete is no longer enforceable.
I think they have to retract it. I agree. Sorry, Ben, I didn't mean to cut you off. Keep going.
No. That's
you got me all riled up. I can't believe they gave that advice. They submitted an amicus brief in the case.
Well, I want to be careful. I haven't seen what SHRM sent to my client. I'm sure it had all kinds of caveats, like you need to talk to your lawyers about this.
That would make more sense.
So I don't want to throw SHRM under the bus, but it does sound like they sent something out that led at least, one company to send the notice.
Yeah. They tend to be pretty careful and pretty good. So I would be surprised if it was as clear as just send this notice. It was probably, to your point, Ben, it was probably something more like, if the rule goes into effect and you need to send a notice, you should consider using this and talk to your lawyer about it, that kind of thing. That would make more sense. And that would be what I would expect from them. But I think now that this client has this problem, it seems to me that the way to address it is to send a recall of it, essentially saying, hey, we sent this out by mistake. We thought the rule was going to be going into effect. The rule has been vacated. This notice is void. And then, it's going to be within a matter of days from when they sent that notice, hopefully.
Right.
And nobody, no harm, no foul. And
it's funny, but I was going to raise the very same issue because in preparation for today, I saw somebody's blog post talking about what if an employer has already issued notices, which I guess a hyper cautious employer had the right or privilege to do. But boy, as an employees council, it's just another thing to complicate a potential injunction.
Yeah, and related to that, John, I mean, another question is we did start seeing over the last, couple of weeks and month or so, some of these judges that were denying injunctions because of the rule and saying, there was questions about, the public policy part of it, and then also on the, likelihood of success on the merits because the rule was going to go into effect. So, if you're in one of those cases, do you're running back into court and ask the judge to reconsider? But also, do we think that judges going forward are going to, even though the rule's been held invalid or been set aside, are judges still going to be thinking about and looking at that and saying, well, thinking twice before they enter injunctions enforcing non-competes?
I mean, isn't that really the larger question at the end of the day? We can talk about what's going on with the attorney generals, and we haven't talked about the NLRB and their activity, but there continue to be very strong headwinds from the judiciary when it comes to the non-competes that are put in front of them. And I think we'll obviously talk about and reiterate advice I feel like we give virtually at the end of every podcast we do about what people should be doing with their non-competes, and that they should be narrow and that they should be judicious in the way they enforce them. But sometimes I perceive that some courts are looking for any reason to not enforce a restrictive covenant, not simply a non-compete, but a non-solicitation agreement, maybe even a non-disclosure agreement. And this gives them some impetus for that. And I can't remember whether we talked about this on a previous podcast or whether this is something I've discussed with you separately, but Ohio is long been a fairly pro-employment state, pro-employer state rather. It's a reformation state, and courts are given tremendous discretion, but it is what's called syllabus authority here in Ohio from the Ohio Supreme Court, that if a court is faced with even an unreasonable non-compete, one that's overly broad, that court is tasked or duty bound to modify the non-compete if there is a legitimate business interest. So just think about that. That is the law in the state of Ohio from the Supreme Court. Even if the court's faced with a non-compete, it thinks it's absurd. It is duty bound to narrow that, to use its discretion to protect legitimate business interests. And we all can debate whether there are trade secrets at issue or whether the customer relationships are truly worthy of protection from that employer. But that's the rule. There was a decision that came out in February, and I've got a blog post that I'd had written into all of the activity with the FTC that stole the thunder from that blog post. And I'll probably get it out soon. But Cincinnati, which has traditionally been perceived as a conservative part of the state of Ohio, the First Appellate District basically disregarded that Supreme Court mandate, came up with a number of rationalizations, in my judgment, as to why it shouldn't apply it. And it affirmed the trial court's ruling to not enforce a non-compete, even if there were reasonable, legitimate business interests that were working. So it's a long way of me saying that, notwithstanding all of the administrative activity that we've seen over the course of the last few years, I perceive a growing judicial ambivalence towards non-competes, and issues like you've raised, Ben, the uncertainty due to all of this administrative activity or legislative activity elsewhere, et cetera, cuts against a likelihood of success. I feel those rationales are going to continue to grow, notwithstanding the vacater or the setting aside of the FTC rule. I'd be interested in both of your thoughts on that, but I frankly was stunned when I saw that decision and read it.
Yeah, and I mean, we all know that one of the elements to get a preliminary injunction in federal court is it's got to be in the public interest, right?
Yeah, right.
And that, I think, I didn't read all of those decisions, but some of the summaries I read, I think that's where some judges were denying injunctions on the grounds that it was not in the public interest. I don't know if I'm saying the standard correctly. It not has to be in the public interest. It just can't be against the public interest, I think is the right word, right?
And I think, and they weigh it as well. I mean, candidly, most courts, in my experience, give it sort of a just lip service to that prong of the injunctive relief analysis. But I think that's a fair point, that people can say, look, there's a real public policy interest against non-competes now. Look what the FTC's done. Look at these academic studies. Look at all this administrative activity by the NLRB, many attorney general acts around I think you can make a good argument for that to some courts that will be receptive to it.
I have more faith in the judiciary. I do not think that they are going to change the approach to non-competes based on public policy grounds that have not been incorporated in the state law, right? Because when we look at the state law, this is ultimately a state law issue. Mm-hmm. And the state law is very clear in these, every state except for 4 that you can use non-competes. They are appropriate tools consonant with the public policy when they are used responsibly. And so I understand that there are these public policy arguments. Those tend to really carry the day when we're talking about the Great Depression, the Great Recession, and there are these real big societal issues. But just because the FTC has come in and said, hey, look, we have these studies in a few states that can't really be generalized, but we are generalizing them to apply to everything and saying non-competes are bad for the world. I don't think a federal court's going to do that. I think, and I don't think a state court's going to do that for the most part. I think that the groundswell of public, let me say that differently. I think that the groundswell of media activity over this that started back in 2014 with Jimmy John's has absolutely left the impression that there is a widespread belief that non-competes are bad. I am not convinced that that is actually true. I think that is, a media skew of it. I think when you argue in front of judges, I think they still are looking straight at the law. This is what it is. This is how I have to apply it. And I get the public policy issues, but unless the state makes a change to our law or the federal government makes a change to the law is what the law is, and I need to enforce it that way, other than your one judge who ignored your Supreme Court.
Yeah, Russell, I can look at, here in Georgia, for example, our statute has an introductory paragraph that says the General Assembly finds that reasonable restrictive covenants contained in employment contracts serve the legitimate purpose of protecting legitimate business interests and creating an environment that is favorable to attracting commercial enterprises to Georgia and keeping existing businesses within the state. I'm going to cite that obviously to any judge that's applying Georgia law on the public interest issue, and that, it's not against the public interest in Georgia to enforce a non-compete. In fact, the Georgia General Assembly has said it's in the public interest to do that.
Yeah, I guess I would disagree with Russell, because I think
would not be the first time.
No, it wouldn't be. But where courts are afforded discretion, you're going to see different outcomes. And I do feel, like it or not, and I agree with Russell. I think so much of the non-compete debate has been colored, just like so many of our other debates in our society, with sort of this Manichaean view of it's either good or it's evil, and we seem to be devoid of the ability to discern nuance or gray area or whatever it might be. But the reality is, judges are human. Some judges bring a certain philosophy to the bench, and I know that there are some judges that I'm going to be in front of, not simply in Ohio, but in other states. And I picked this up from my local council that have a certain view when it comes to non-competes. And whatever that standard might be, that view is going to either be disregarded in some cases, or perhaps unconsciously they're going to eke a ruling out that's consistent with their perception. So I do think, yes, the law is the law. And if you've got a straightforward statute or a straightforward rule, a court should apply. But I think if there's discretion, and particularly when we're talking about equitable remedies, which are inherently discretionary, I do think there remain strong headwinds that are only growing. And the FTC's rule, while ill-conceived, is yet another one of these strong headwinds that we're all encountering with attorney generals, with the NLRB, with legislation, et cetera. So I've said too much. I'll step back and let Russell put me in my place.
No. I think we can harmonize our views, actually. I think your point that different judges come to these cases with different preconceived notions. Some tend to skew more employer friendly. Some tend to skew more employee friendly. These are inherently equitable cases, as you've said. They are inherently fact dependent, and a judge that skews in one direction certainly can justify a decision in line with that. And this is one more arrow in their quiver, I suppose. But I don't see that this materially impacts their analysis. I think that what actually impacts their analysis is what you identified, which is their general tendencies from the get-go.
Well, now that you all have harmonized your views, we should sing Kumbaya and maybe try to wrap up.
Should we talk about the things that we are suggesting people consider in light of this outcome?
I think that's a good idea.
So anybody want to kick that off?
Ben, why don't you? Do you mind? I mean, you've been a superb moderator, but I'd be interested in hearing your thoughts.
Well, I mean, we've
the aisle.
Yeah, we've talked about a lot of these issues, right? And I think that it does go back to what we've been telling clients for years now, which is to really be taking a hard look at the other things that they are doing to protect their trade secrets, protect their confidential information, protect their competitive edge, because as you guys were just talking about, there is this ongoing assault. This isn't the end, right? Whether it's Congress or whether it's the state legislatures, it is getting more and more difficult to enforce non-competes. And, I think that at the lower levels, it's easy when you got the guy changing someone's oil or the security guard. I think at the highest levels, it's not easy, but it's easier to convince a judge that, you can't go from being the CEO of Coca-Cola to the CEO of Pepsi. It's everything in between where it's going to continue to be more and more difficult to enforce non-competes. So to me, the biggest takeaway is the same one we've been talking about for quite some time, which is looking at all of the other things you can do to protect your business.
So let me circle back to what you just said, because I want to make sure that we're clear on it. The FTC rule we know now is gone. We still have the FTC enforcement actions. They're going to go after companies that are either abusing non-competes, which goes right to your point. Don't use non-competes where you don't need to. So that's number one. And then you can avoid that prong of what the FTC is going to probably do. And the other is that the FTC will go after some companies that are going to make headlines. So if you're a company that is going to capture the headlines, be very careful what you're doing with your non-competes. I don't expect the FTC is going to come out with hundreds of these cases. I expect they'll pick a handful of them. So beware of that. The second thing you said, Ben, is that it's not just the FTC piece of this. There's also Congress. There are still 6 bills pending in Congress around non-competes, 4 of them that actually matter. There were 4 bills out of the 10 this year in the states that proposed outright bans. So those are still out there. Many of the state legislatures are in recess at this point, but we can expect that that's going to continue, and we'll see more of those moving forward. So the best thing companies can do right now is to recognize exactly what you said. The assault on non-competes is not going away. It's going to continue, and it's going to be eaten away at. The use of non-competes is going to be eaten away at in the states, if not ultimately completely eradicated by Congress. I don't really think that's where it's going to go in the short run, but I think companies should be thinking about that and really focused on all these other tools that they have available. There are lots of creative ideas that people have come up with over the years, and especially as the FTC rule has been looming. And I think that companies should really be thinking about that. And the most important thing is preventing your information and your relationships from walking out the door in the first place. And so you really need to be thinking about how you make sure that when somebody leaves, they are not in a position to take your information and to take your relationships. I mean, that to me is kind of the key.
I agree. And then I think you mentioned it, but I think in addition to the FTC enforcement actions is like this Valvoline thing, the state enforcement actions, and being aware of those where you have people, if you have people in various states around the country, is understanding how the risk differs from state to state, just like you need to understand the enforceability of your covenants generally is, understanding if you have a non-compete in a particular state, are you opening yourself up to risk that there could be some enforcement action by an attorney general.
I agree.
No, I would agree. I think you both have summarized the way I'm thinking about it too. Be judicious in the use of your restrictive covenants. If you can using a non-disclosure agreement or a non-solicitation agreement, if you have that embedded within your agreement, that should be your first option. Save the non-compete claims or actions for only the most egregious situations.
I really like notice provisions, notice requirements.
I do too. I do too. I mean, they really. That's an excellent. Go ahead, Russell. I'd like to hear your.
Yeah, the thing about notice provisions that I think is the toughest thing is that it's one thing to say to someone, you have to give X number of days notice if you intend to leave, right? The question is, if you give that notice and then you decide to breach the provision by going to work for a competitor during the notice period, if the notice provision goes further and says, not only must you give the notice, but during the notice period, you cannot work for any company or a competing company, I think in most instances, that's just going to be treated like a non-compete because.
But it's a garden leave non-compete, right?
Well, yeah. And if the person's getting paid, perhaps, but I think a lot of judges still don't like the idea. And I've won on that, twice here in
which
Georgia.
Direction? You've won enforcing or defending?
Defending, where the employee did not give the notice, immediately started with the competitor. The former employer ran into court to try to get an injunction. And in both instances, I was able to say, Judge, look, this involuntary servitude went out with the 14th Amendment. You can't require my client to remain employed, even if you're going to continue to pay them. And in both cases, the judges agreed. Now, that's anecdotal, right? That's not empirical. I don't know if anybody's ever done a study as to how those cases have come out around the country. But at least in my cases, it's not a silver bullet that gets you something that the non-compete won't. It might. And in some instances, it probably should, but it doesn't always.
No, that's a fair point. There's inherently some risk in doing it. But I think in terms of attempting to use it, I think it's really beneficial. And I don't want to extend this any longer than we need to. I know we've covered a lot of ground here, but it allows a cooling off period for these departure situations, which can become volatile. It allows the employer to judiciously, and I've been using that word a lot today, but to be careful and appropriate in the way that it handles things, and it provides that, particularly with customer relationships, the passing of the baton. It allows for a thorough investigation, if necessary, to make sure that information isn't being improperly taken. I really like it, and I've seen clients increasingly doing it and asking about it.
Same here. And so let me just end this on this part of the discussion, and then I think we could wrap up. But I think on the notice provision, Ben, you had made the point in one of our earlier shows that in the context of a notice provision, you should explain why you need the notice. And it's exactly what John just said. So you include those concepts in there. And I think the other piece is, so couple it with a springing non-compete or the timeout injunction or whatever you're going to call it. And that way the remedy is built right in. If you don't give us the notice, Judge, here's what they've said should happen. They should be out of the job until the notice provision expires. Yeah,
I agree. And just to correct myself, I said the 14th Amendment was the 13th Amendment.
I was going to correct you, Ben, but I decided I would leave it.
All right, fellas. Well, I think it's been a good discussion. Lots of interesting issues to think about. I think the judge's ruling in Texas gives us at least some clarity going forward, at least with respect to the FTC's rule. But it doesn't mean that the freewheeling use of non-competes like the Jimmy John days are back upon us.
I agree. Well, thank you, guys.
Yeah, thank you.
Yeah.
That concludes today's show. You can visit the official podcast website at fairlycompeting.com. And please note that this show is provided for informational purposes only. None of your hosts is providing legal advice, and your use of this podcast does not create an attorney-client relationship in any respect. Thank you all for joining us.